Okay, I think we're live now. All right. Hey, everybody. Good afternoon. Sophia Towns here with Low Country Autism Foundation. I am the program coordinator. And today we have a very special guest. We have Todd Kenney, who is an attorney who specializes in special needs estate planning, trusts, guardianship, and conservatorship. So as a special needs parent myself, it is a very big stressor that I think about daily, and that is what happens when I don't wake up tomorrow morning? What happens if I don't wake up? What is going to happen to my two boys with moderate to severe autism? Where are they going to go? Who's going to take care of them? How are they going to live? It's a lot to think about, and I will say it's not a subject that we talk about a lot with our friends and family, but I can tell you as a parent, we think about this every single day, and it's probably our number one concern is what happens when I leave this world. How are my kids going to be taken care of? Well, Todd Kenney is here, and we are going to talk about it today. And he is going to help ease our minds and coach us into making those good decisions and giving us some wonderful advice. So I am going to turn it over to Todd, and there you go.
Thank you, Sophia. My name's Todd Kenney. Like Sophia said, I'm an attorney here in Charleston, South Carolina. I have a practice with my wife. She's my business partner. Her name is Sarah Kenney, and the two of us are the Kenney Law Firm. And this is the area of law that we specialize in: estate planning, creating wills, trusts, powers of attorney, things of that nature, as well as guardianship and conservatorship proceedings. So today we wanted to talk specifically about special needs planning and exactly how do we get from point A to point B. And unfortunately, it can be a legal minefield. So we wanted to kind of go through those different issues today, just so we can get everything out on the table so that we can have a good informed decision in conversation with our other family members. Because what I don't want to see is, like Sophia said, we pass away, our child is receiving these benefits, and then all of a sudden they have lost their benefits because we did not do the proper planning, or they maintain their benefits, but at a cost. So we're going to talk about all of those issues today. Let me pull up our slide presentation. So what is Medicaid? So Medicaid is, of course, a federally funded program that is enabled by the states. So here in South Carolina, Medicaid is actually called Healthy Connections. And your eligibility, or the eligibility for your child, is determined by their age, whether or not they are pregnant, if they do or do not have a disability, as well as their income level and assets. So generally, in order for the applicant to be qualified for Medicaid benefits, they must qualify under Supplemental Social Security, or SSI. As a general rule, again, there are 14 subsections to Healthy Connections, but as a general rule, the individual, the beneficiary, cannot have greater than $2,000 in assets. And there will also generally be a level of income that they cannot surpass. Generally, that's going to be between $1,500 and $2,300 per month. So the money can come in. If they were to get greater than $2,300 a month in income, so they get a pay raise and they're now getting $2,400 a month, they could possibly lose their benefits. Additionally, if we are not spending that money at the end of the month, so we have a Social Security check coming in, or they are able to work, and that income growth accumulates to greater than $2,000, again, we could put their benefits at risk. So those are the two parameters that we always look for. Now, there is a list of exempt assets that does not qualify into that $2,000, such as a primary residence, a motor vehicle, annuities titled into the individual's name where they are the annuitant, burial plots, certain types of business interests. So there are some things the child can own that would not qualify into that $2,000. But I just like to impress onto my clients, keep in mind the $2,000 threshold, okay? Because it's very important, and we do not want to lose the benefits because our assets have exceeded that value. So what is a trust? A trust is just simply a legal agreement that creates a relationship where property is held by one person or individual or entity for the benefit of another. So essentially, if I were to pass away, my minor children, I have appointed my sister to be the trustee for my minor children, okay? So a trust is basically just a scenario where it is a legal agreement, is an entity, where we have one person managing funds for another. So what's a special needs trust then? So it is designed specifically to provide benefits to and protect the assets of individuals with either a physical, psychiatric, or intellectual disability, and would still allow them, those individuals who are qualified to receive benefits, to continue receiving the benefits, even though they've received an inheritance that is greater than that $2,000 in assets. So essentially, mom and dad pass away and they have, say, $1 million in assets. They have a special needs child who is receiving SSI and Medicaid benefits. If those assets upon the death of the parents are transferred into a properly created special needs trust, your child can literally have $1 million in assets and their Medicaid benefits. It's kind of having your cake and eating it too, okay? So there are 3 positions to every trust. There is a trustor, a trustee, and then of course the beneficiaries. The trustor, that would be the person who is creating the trust. The trustee would be the person who's managing it for the benefit of the beneficiaries. Okay, so those are our 3 positions. And it could be, and we'll talk about this as we go through with a revocable living trust, where you as the parent actually fill all 3 positions initially. And then after your passing, we would separate the trustee from the beneficiary. And we'll talk in more depth about that in a bit. So the trustor, of course, like we talked about, that is the person who actually owns the assets and transfers them into the trust. In the special needs arena, that can be a group of people. It could be the parent, it could be the grandparent, a guardian, a court, or even the individual, the alleged incapacitated individual, or the person who's receiving benefits. The trustee, this will be the person who manages the assets within that trust. They would be able to buy, sell, take out mortgages, loan money, or if we need to just move monies around within the investments, the trustee would be the person who does that. And then they would make the distributions down to your child as the beneficiary, which leads us to the beneficiary, which is, of course, the person who gets to have access to the funds and spend the money within the trust, okay? So 42 USC 1396P is the statute that governs special needs trusts, okay? There are different types of special needs trusts. We're going to go through 3 of them today, the 3 most common. And they would be the D4A special needs trust, which is a self-settled trust. The D4C is a pooled special needs trust. And then we also have third-party trusts. So we're going to go through all of those today just to kind of explain the differences in each and why we need to do this planning up front ourselves for our children, instead of just kicking that can down the road, we pass away, and then trying to get into the D4A self-settled trust. We'll explain that more here as we go. So let's start off with the 42 USC 1396 PD4A special needs trust. So the benefit to these trusts is to provide quality of life for the Medicaid beneficiaries. And the trust is funded, and this is very important, the trust is actually funded with the disabled beneficiary's own assets. Well, you're probably thinking, my child doesn't have any assets, what am I funding this with? That would usually come from 2 scenarios, or 2 main scenarios that I think of. The first would be, we have another family member, an aunt, an uncle, a cousin, brother, sister, who has left in their will a distribution to our special needs child. I actually had this happen 5 times last year with my clients who were receiving special needs benefits, where some other family member has left somewhere between $20,000 and $50,000 to my beneficiary who is receiving the benefits. If they were to accept that distribution, well, that $50,000 is greater than $2,000. They have now just lost all of their benefits. So they would have to spend that $50,000 down, then go through the reapplication process, which obviously we do not want to do. In each of those situations last year, I had my client disclaim or say, thanks, but no thanks. I don't want that inheritance. It would then act as if my client had predeceased the giver of the gift. So now that distribution, that $50,000 just goes to somebody else. That's a terrible thing to do. You know, if the uncle or cousin or that individual wanted us to receive that money, then we should be able to receive that, but it has to be done correctly. The other scenario where the D4A special needs, self-settled special needs trust would come into play is if your child was to receive some type of settlement. They've been injured, they've been in an accident, and they receive a settlement, okay? So those will be their own individual assets. Again, generally from an inheritance or from a personal injury type lawsuit, okay? So in order for us to create the D4A special needs trust or self-settled trust, there are some qualifications that we have to go through. So first, the beneficiary must be under the age of 65. If they are over the age of 65, this type of trust would not be an option for us at this point in time. The benefits or the assets within that trust must be for the sole benefit of that disabled person. It must be created by the parent, grandparent, guardian, or the court. The individual, the disabled individual, cannot create this trust themselves. So as you can start to see, we're already setting foot in the court so that we can get this type of trust created. Again, it is funded by the disabled beneficiary or the disabled individual. Again, that money has to come to them first, then it goes into their trust. And here's the big catch. After our special needs beneficiary passes, the state Medicaid agency must be reimbursed for the cost of the medical assistant which was provided to that individual. It's called the payback provision. So let's just say, for example, Uncle Jim left me $50,000 for my special needs child. It's in a D4A special needs trust. And my child passes away literally the next day. During my child's lifetime, Medicaid has paid over $100,000 of benefits towards my child. Well, the remaining assets in that trust, the $50,000, must first go back to Medicaid and pay back dollar for dollar any benefits they have provided to my child during their lifetime. Okay, so it's essentially going to be washed out. I would assume there would be no money left there. If there is any money left out, then the trust would pay to the next beneficiary, either another child or whoever the beneficiary would be at that point in time. Okay, so again, the downside to the self-settled trust would be that we have to pay that money back to Medicaid. So if mom and dad have not done the work themselves, mom and dad pass away and they have a child who is receiving SSI and Medicaid benefits, we would create a self-settled D4A special needs trust. Then when your child passes away, whatever's left in that bucket would go back to Medicaid, and then the residuary, what's left, would come back to your other children. Okay. That's not good planning in my opinion, because this is going to come out terrible, but I'll say it anyways. I don't want Medicaid to have that payback provision. If we do the planning up front as the parent, I can have it be in trust for my child, and then upon my child's passing, I direct where it goes. Not back to Medicaid, I direct where it goes. Okay, and we'll touch on that when we get to the third party trust here in just a bit. Pooled trusts. So pooled trusts, again, are governed by the same statute, 42 U.S.C. 1396 P, D4, and then D4C is this pooled trust. So generally, and I'll be honest, I've only created 2 pooled trusts in 15 years of practice. I'm not a huge fan of them. Generally, where I would see a pooled trust be utilized is if we are going to be providing to our child under $100,000. If we're going to provide over that, I would suggest using a third-party trust, which we'll talk about in a moment. But with a pooled trust, again, it can be created by just about anybody. It can be created by the parent, the grandparent, the guardian of the child, the court, or even the disabled individual. The disabled individual can actually create their own D4C pooled trust. Here's the catch. You do not get to name the trustee. The money manager will be a nonprofit organization that's been set out here in the state of South Carolina. They would serve as the trustee for your child, okay? The thought process behind a pooled trust is that if I'm only investing my $50,000, with a compounding of interest, it's going to take a long time for that $50,000 to grow to a significant number. Whereas if I take my $50,000, Sophia's $50,000, Joe's $50,000 over here, and Susan's $50,000 over here, well, now I have $200,000 to invest. I can make that grow a whole lot quicker. Okay, so with a D4C special needs trust, the pooled trust, it is a separate account managed for each beneficiary. So my $50,000 that I've put into the pooled trust is only there for my named beneficiary, my child. The next door neighbor's child cannot touch that money. Nobody else's child gets to touch that money except for mine. But we're investing them all together so that by compounding of interest, it's going to grow much quicker. Okay. Here's the catch at the death. At the death, the balance of that trust, whether it's $1 or $50,000, it is retained by the nonprofit for the benefit of the others or paid back to the state Medicaid agency. So again, with a pooled trust, I don't get to say if my child dies, it goes to my other children. It goes automatically back to the state agency, the nonprofit organization, and they will use that residuary for the other individuals for their Medicaid benefits. Okay. So a pooled trust is a great thing if we have a very small amount of money to be utilized to just try to get that to last a little bit longer. Try to earn as maximum as we can for that. But again, if the death occurs of your child and there still is a balance in that trust, that balance would go back to the state agency. So third-party trusts. With a third-party trust, we have a whole lot more latitude as far as distributions go, and we'll talk about that here in just a bit. Again, the key with the third-party trust is that I create the trust for my child, my disabled child. When my disabled child passes away, we do not have a payback to the Medicaid situation. It goes directly to my next named beneficiary, whether that's another child, a charitable organization that I have named. I get to decide where it goes. So I stay in control of those assets. So again, the third-party trust is just as it sounds. It is created and funded with a third party's assets. So I would be that third party creating the trust and funding it with my assets for the benefit of my child or children. There is no age requirement. It must be, though, for the sole benefit of that disabled child. So if I had multiple, say I have two disabled children, two children receiving SSI and Medicaid benefits, what I would do in that situation is just separate those two shares. So I have one share, 50% for child A, and then I have a separate trust share for child B. So that would say that each child is the beneficiary of their own individual trust share, and it would qualify. Then the remainder is distributed to the named beneficiaries. So like we talked about, upon the death of the child, we are not giving it back to Medicaid. It is going to the next beneficiary that we've named in our documents. So before we move on to question and answers, what if we have a child who does have the diagnosis of autism, but they have not yet started receiving SSI and Medicaid benefits? Now what do? Do we just give it to the child when they turn 18 and cross our fingers and hope and pray that everything goes swimmingly? That's not a good plan, in my opinion. What I like to do in that situation is to create what's called a discretionary trust. So if we go back a few slides, I had so you can see here that the trustee has much greater latitude for distributions, including discretionary distributions. So with that provision, it would be up to the sole and absolute discretion of the trustee what the beneficiary would receive. So for example, again, my child is not receiving SSI and Medicaid benefits, but they do have autism and they are susceptible to people coming forward to them and saying, hey, Todd, why don't you let me have some of that money? Or let me invest some of that money for you, and then they take it and run, and there's no way for me to get that money back. So with a discretionary trust, the trustee can distribute as much or as little to the child as they need to have to continue their life, okay? So we could pay for rent, we can pay their mortgage, we could pay their car note, their utility bills. We could pay everything out of that trust for the benefit of the child. With a discretionary trust, no outside party can force or compel a distribution. So if your child owes the hospital $1 million for all the surgeries, procedures, therapies, whatever it may be, they owe $1 million to this entity. You've passed away, and that entity comes forward and says, well, I see that you've inherited all this money. Why don't you go ahead and get all of your accounts up to date and pay us the money you owe us? The trustee can say absolutely not. And again, nobody can force or compel that distribution to be made. The trustee is in complete control, okay? And again, it would be a discretionary trust up to the sole and absolute discretion of the trustee. Then again, as we discussed earlier, it would still be a third-party trust. So at that time my child passes away, we would decide where the money goes next, okay? So it's really about maintaining the control of the assets and putting your child in the best position moving forward. I never want to see a scenario where we've not done the planning, then we have the unfortunate passing. And now we're trying to scramble to get us back to square one. Okay. So creating the trust is just the first step. Once we create the trust, you have the shell. But now what we really have to focus on once we create that trust is distributing the assets from you to your trust. For example, whenever we create a special needs trust for a client, we would transfer the home, the automobiles, the vehicles, things of that nature. We would transfer all of those things into the trust so that the trust owns those assets. So if you look at my deed to my home, it doesn't say Todd and Sarah. It says the Kenney Living Trust, dated blank, the date that we signed the documents. Beneficiary designations, life insurance, 401ks, IRAs, bank accounts, checking, savings, money market. All of those types of accounts have named beneficiaries. The named beneficiary receives the assets. So it does not matter if you have created a trust. If your life insurance policy names Todd as the beneficiary, when you pass away, that account is coming to me. It is not going anywhere else. I'll give you the unfortunate real life example. It actually happened to my little sister with beneficiary designations. So my little sister, about 3 years ago, her husband passed away. He was born with a congenital heart defect. He was born with a bicuspid aortic valve instead of a tricuspid aortic valve. So he knew at some point in time, he's going to need to get this corrected. Well, the day that he went in to have surgery, unfortunately, the valve did not take, and he ended up passing away. As the estate planning attorney, prior to him going in for surgery, I had a conversation with him. Corey, let's create a will for you. So if God forbid something were to happen, we're in line, and everything would go to my sister Amber. And if God forbid something happened to both of you, then it would go down to your son Zaid. Great, everything was taken care of. Told Corey, make sure you get your beneficiaries designated to my sister and then down to the trust. Already took care of it. Corey then passes away. At the funeral home, we find out that Wes, his brother, was actually the beneficiary to both his life insurance and to his retirement account through the employer. And at the funeral home, Wes let Amber, my sister, know that he was just going to go ahead and keep that money to raise his family. Ouch. And there's nothing Amber could do to stop that. So we need to, it's not need, it's imperative that once we create these types of trusts, that we work with our financial advisors to make sure that life insurance, retirement accounts, 401ks, 403bs, your IRAs, all of those policies have the trust named as the beneficiary. Because I don't want to see a scenario where, we've spent all this money, we've created this wonderful trust, but then we fell short of the finish line and now all the assets just come outright to your child. That would create a scenario where we have a pooled trust or the third party trust for like your house and your car, but then we'd have to go and create a D4A trust for the investments. Does that make sense to everybody? I hope. That's kind of a shift there. But we could end up with having two separate trusts for our special needs child, one for the assets that were created correctly, and then one for the assets that unfortunately were not handled correctly. Okay. So it's very important to maximize those beneficiary designations and make sure that those are updated to mirror what our plan is. With the titling of your home, and this is something I want everybody to do when you get home this evening, or if you're already at home, check it out. I would like for each of you to look at the deed to your home. Up until probably 2015, I would say 90% of the deeds that I see are drafted individually as what's called a tenant in common. So prior to 2015, if my wife and I bought a house together, it would just say Todd and Sarah on the deed. If that occurs, Todd dies. Well, now Sarah, my wife, is going through probate for half of my house. Please give me the example where I die and I don't want my home to go to my wife. I mean, I think she's the perfect person to have 100% of my house. I sure don't want my house to go down to my children so that my children own half and my wife owns half. So if you have the verbiage on the deed, I want it to say husband and wife as joint tenants with the rights of survivorship and not as tenants in common. With just that simple verbiage, Todd dies, now everything would convey to Sarah and she would not have to go through probate, okay? Or we could title it into the revocable trust as we discussed previously. Questions at this point?
Not yet. I don't see any questions yet.
Perfect.
Yeah.
I'm doing a good job.
Yeah, you're doing great.
Would you like us to switch over to the guardianship conservatorship?
Sure.
Perfect. Give me just 1 second to click out here. Perfect. So guardianship and conservatorship. So guardianship is the process of taking control of another person, essentially. So it is a process by which a court determines that an individual has become incapacitated and they are unable to care for their own physical well-being. Okay, so we have two positions here. First, we have a guardian, and then we have the ward. So the guardian is going to be the individual who's been qualified and appointed by the court to care for our individual who's been incapacitated. And the ward, of course, is the individual who the court has determined is incapable of caring for their own interest. So if your child, and here's where we really get into the guardianship issue, is when we have a child who has been diagnosed with autism, mid to low functioning, and they go to the doctor. Well, once they turn the age of 18, their age of majority, the physician now cannot legally give you any of their health information without your child signing off a HIPAA release. Well, if my child is unable to sign that HIPAA release and the physician is going to give them medications, how am I going to monitor those medications without going through guardianship? It's almost imperative at that situation that we go through guardianship so that we can stay in control of the child to make sure that everything is going according to plan. So incapacity. Incapacity, the court could find an individual to be incapacitated or incompetent due to mental illness, a mental deficiency, physical illness or disability, advanced age, chronic use of drugs, chronic illness, or for other reasons, such as a minor turning age of 18. Or if we have a minor child and I pass away and Sarah passes away, well, now I've named my sister as the guardian for my minor children. So the guardianship process, I'm sorry, go ahead, Sophia.
No, so sorry to interrupt. I don't know if I'm seeing the slideshow for guardianship.
Okay.
The one I'm seeing is third party. Sorry.
That's okay.
And it could just be me. I just want to make sure everyone can see there we go. Awesome. Thank you.
Perfect. Sorry about that, guys. My daughter wasn't here to tell me which button to click on. So the guardianship process, it's not as if we just walk into the court and say, hey, judge, my child is disabled and I need to become their guardian. Will you give me a sheet of paper saying I'm their guardian? It's a little bit more complex than that. So it's a process just like any other court proceedings. So we'll file a petition with the court. All members of the family, immediate family, must be notified. So mom, dad, your disabled child, all of your other children must be notified that we're going through this process. Additionally, the court is going to appoint a medical examiner, which must file a report stating the recommendations to the court. It doesn't have to be that the court recommends that medical examiner. You can use your child's physician. We just have to have the examiner's report filed with the court, okay? The ward is going to either retain an attorney and a guardian ad litem, or the court will appoint one for them. I can't think of a scenario in my 15 years of practice where the ward actually retained their own attorney. Every single case that I've ever been involved with, the court has appointed the guardian ad litem and the attorney. But they would have both an attorney and a guardian ad litem. And those individuals are there to represent your child, to make sure that their interests are being recognized, okay? We'll also have a hearing. And during the hearing, we're going to determine whether there is capacity or not. So the court must find that the ward is incapacitated and that the beneficiary or the individual is in need of a guardian. The court must also find that the guardian is qualified to serve. So in the event you have been charged at some point in time with abuse or neglect of an individual, whether that be an elder or a minor, that would probably disqualify you to serve as the guardian for another individual because they want to make sure that you are in a good position. The duties of the guardian. Of course, the duties of the guardian are going to be to care and comfort the ward. So, just day-to-day life, scheduling doctor visits and any other needed appointments. You will have to report to the court annually as to the mental and physical status of the ward. So we're just going to have to, it's a form filled, it's created by the court. It's, I think, 13 questions. They're all very straightforward and simple. It's not trick questions, but they just want to know if there's any change in the mental status or the physical status of the ward or the individual. And then we must also report financial matters that we've handled to the conservator or to the court. Going back on the annual report to the court, sometimes things change. So we had a client a few years ago where they had a high functioning autistic child that we had gone through guardianship years before. And the individual just grew and grew and grew. He was at the time, I believe he was 26 at the time. And mom and dad had about a 10-acre parcel of land. They had their house, of course, and just open field. So they wanted to start teaching their son some independence. So they brought a mobile home onto the property, put it back behind their home, and their son started to live in the home. And so that year we wrote the report to the court saying over the next 365 days, our child is going to live in the mobile home behind the house, and we're going to start working on independence. That only lasted for about 3 weeks, and he was ready to come home. So at that point in time, we had to update our report to the court saying it didn't work. He's moved back in with us, and we're all now living at the house together. So we have to keep in constant contact with the court once we go through guardianship, just to make sure that the ward, the individual, is being cared for the way that they should be cared for. So again, guardianship only deals with the body. Conservatorship only deals with the money, okay? So again, conservatorship is a process by which the court determines that an individual is incapacitated or incompetent and unable to care for their own financial affairs. The conservator is the individual who's been qualified and appointed by the court to care for the property and assets of the incapacitated individual. So they would be in control and charge of all of those finances. And again, they'll be required, as we'll see here in a bit, you're going to have to show to the court each year what monies have been spent and for what purpose. We do not want a scenario where you are using the ward's money for your own personal benefit, paying on your mortgage or your car notes, credit card bills, so on and so forth. And of course, the ward, like we talked about with the guardianship, it's the individual who the court has determined is incapable of caring for their own financial interests, not personal interests, but financial interests with conservatorship. So there must be 3 determinations by the court for conservatorship. You must have property greater than $15,000. If the individual ward has less than $15,000, we do not need to go through conservatorship. The guardian would be in control of the funds if it were less than 15. If it goes in excess of 15, then we'd have to file for conservatorship as well, okay? The property must also require management or protection, and that management or protection could not be done otherwise unless we go through this conservatorship process. So the process, it's very much the same as the guardianship. It's actually generally done in conjunction with the guardianship. So we'd file both petitions at the same time. The hearing would be all held at once, and then the judge would just appoint the parent as both the guardian and the conservator. So again, a petition would be filed with the court. Again, we have to notify all immediate family members. And then the court is going to, again, just like we talked about with the guardianship, appoint a medical examiner, which must file a report with their recommendations. Again, the ward is going to be appointed or must retain both an attorney and a guardian ad litem. It could be the same person, but doesn't have to be. And then it will also, again, have a hearing that the court must find that the ward is incapacitated and is in need of a conservator. Additionally, the court must find that the conservator is qualified to serve. So here, what they would look at is your credit score. You know, generally, I'm just trying to rack my brain. I can't think of any courts currently. I'll take that back. Marion County did not require. Excluding Marion County, every other court that I've worked in, they will require the conservator to take out what's called a surety bond. It's basically an insurance policy. So that if you were to steal the money from your child, the surety bond would pay back to make the estate whole. Generally, that surety bond is going to be 1.5 times the value of the assets. So if your child has $100,000 in assets that we're going through conservatorship for, the court would require you to take out a $150,000 surety bond. It's just an insurance policy so that if you were to steal the money, it would pay back to the child to make them whole again, okay? So the duties of the conservator, again, manage and protect all assets of the ward. Going to have to pay all of the bills and expenses. You will have to file an inventory and appraisement with the court. So at the very outset, within 30 days, you're going to have to submit a filing with the court saying this is the assets of the alleged incapacitated individual or the ward. You will file letters with appointment in the county in which the ward owns property. Of course, we'll post a surety bond like we talked about. And then again, we're going to have to file an accounting each year with the court so that we can show to the court exactly what monies have been spent and for what purpose. Allowable expenses. The court may approve regular expenses for care of the adult ward. It's a budget. So what I always do with my clients is sit down with them after we go through the conservatorship and we set out a budget. Let's just say, for example, our child's expenses are $1,000 a month. We haven't gotten to this part yet, but the court will not allow us to expend any amount greater than $500 without prior court approval. So if we want to send our child to have this therapy and the therapy is $600 or $500, $501, we would have to petition the court and say, Judge, I want my child to receive this therapy. This therapy is greater than $500. Can I spend the money? And then the judge would write back yes or no. Okay. The alternative to that is to create a budget. If I know my child's going to receive this therapy every month or every quarter or every other month for the next year, I can submit a budget to the court saying these are the monies that are going to be spent throughout the rest of the year. The judge would appoint them. Then we can just go ahead and pull that money out each month or each quarter, however we need to do that to pay the bills. Then anything in excess of that, over $500, we'd have to petition the court. Okay. So a minor ward's money cannot be used for their care and maintenance. That must come from mom and dad. And it must be protected until the ward reaches the age of majority or 18, or if there is a special exception by the court. So if we needed to spend anything greater than that, we'd have to petition the court and ask them. Again, any expenses must first be approved by the court. Ways to avoid the guardianship and conservatorship. It really depends on the situation, but a healthcare power of attorney. So if we have an individual who is not incapacitated, if you're incapacitated, there's no way to avoid that. But if the child is not incompetent, we could create a healthcare power of attorney. The healthcare power of attorney would negate the need for us to go through guardianship. A healthcare power of attorney just simply names an agent who is going to make all of the healthcare decisions for the individual. It avoids any unwanted medical procedures because now you as the parent can tell the physician, we are going to do this procedure, but not that procedure. And it helps that conversation so that everybody in the family is kind of on the same page. So as these things come up, we've already had these discussions. I want to pause here for a moment just to kind of expand that discussion with healthcare power of attorney agents and decisions in the time of COVID. So the way that and this applies to all of you on this call, as well as our children who are creating healthcare documents, or your parents, your grandparents, everybody this would apply to. The way that the South Carolina documents for healthcare powers of attorney and living wills are drafted, it basically states that if I have an incurable or inoperable disease, I elect that either I do or I do not want my life to be continued in that state. Or it specifically states, I do or do not want nutrition and hydration to be provided or to not be provided for me if I get to that position. My greatest concern would be that I'm on a ventilator, I have been diagnosed with COVID, and at this point in time, there is not a cure for COVID. So it is by definition an inoperable and incurable disease. My concern would be I'm on the ventilator and I've marked on my living will and healthcare power of attorney that I do not want to be kept alive artificially, as Terry Schiavo was down in Florida, 30, 40 years ago. Then it plays through that an 18-year-old has just presented into the emergency room and they have COVID and they need to use my ventilator. I have a great concern that physician would come to my wife and say, sorry, Sarah, but Todd has marked on his documents that he does not want to be kept alive artificially. He wants to be dead. So we're going to go ahead and take his ventilator and give it to this guy over here. I do not want to even have that discussion. The healthcare power of attorney and the living will both give us the avenue or pathway to where our agent can have that burden or power to say, I understand what they want, but I'm going to change that fact, okay? So it's grant of the discretion to the agent. That's how I would want each of those documents to currently be designated, only because of the COVID situation. Literally in 15 years, I have not really been a big fan of that designation until this COVID-19 came through. Now it's scary. I can't really say much more about that. So just make sure that everybody in the family knows what your wishes are. And then to avoid conservatorship, if we have a properly drafted financial power of attorney, again, that would name an agent who's going to pay all of my bills for me. So if I've already named an agent to pay my bills, I don't need to go through the court system so that they name someone to pay my bills. So the other way would be to create that financial power of attorney. Here in South Carolina, the financial power of attorney has to be recorded just like a deed. Okay, so in order for us to utilize that, it would be recorded down at the Register of Deeds office, and then we can use that document to gain access to all of the accounts. Questions for me, guys? I know it's a lot of information.
I've not received any questions yet on guardianship or conservatorship, but I have someone would like for you to review what to do if someone wants to leave your special needs child money. What do you need to tell them? How should they prepare that?
Great question. What our office does a lot, and this is kind of an odd question to ask, but I encourage my clients to do this, to ask all the other family members, are any of you going to contribute to my child? If we find that there are going to be multiple people contributing to your child, parents, grandparents, siblings, we can create one trust so that everybody can contribute to that one trust. As opposed to, you've created a trust for your child, your mother has created a trust for your child, your in-laws have created a trust for, well, when we get to that situation where we have multiple trusts, well, now we're just spending money that isn't needed to be spent. Each year, those each trust will have to file a tax return. There'll have to be an accounting done. So there's going to be some work that needs to be done. And if we have multiple trusts, that's just going to eat into the value that should be going to our child. So what I like to do in that situation, if we do have multiple family members who are going to be contributing to our disabled child, let's just create one bucket, and then we can provide the name of that bucket to everybody in the family. And then they can write into their will, if I were to pass away, I want X amount of dollars or my entire estate to go into this specific trust. Great question. Very good question.
Okay. Okay, great.
And I hope that answered your question.
Yeah, no, I think it did. I think it did. Just checking here. Any more questions? Don't hold back. Feel free to drop a question in the comments. I think a lot of people too, I had some families say they couldn't tune in right at 3:30, but they wanted to make sure that we were going to have this available. This video available to watch at a later time, and we most certainly will. You can look for it on our Facebook page, and you will be able to access this and watch it. And you can always send us your questions, and we have also included Todd Kenney's contact information to his office in the comments, so please feel free to reach out. This is definitely something that is not an easy subject to talk about, but it's definitely something that we need to talk about, especially with our special needs children. So Todd, thank you. Thank you so much for doing this. Thank you so much for doing Facebook Live with me today. This was our first. So guys, you guys have a great afternoon and take care, and we will see you back soon.
Thank you all so much.
Bye, guys.